want to introduce our first presenters, Scott Booth and Anna Lang. For once in my career, I was at a loss for words as to what to say about these two bright young stars. What a powerhouse team. The first line of their bios says everything you need to know about them. Anna, quote, her practice bridges estate and family law with a huge array of experience over her, I won't say the number of years, it's 20 plus years of practicing law.
Almost 30, yeah.
And Scott, the first line of his bio says, his practice focuses on problem solving and helping his clients obtain solutions to challenging problems. And I just want to, and that's not opposed to what Anna does, okay? I just want you to know that. We've put them together to do a presentation on something dear to your hearts and dear to your revenue if you act for the successful applicant for interim advances. So I turn the mic over to my two very learned friends, Scott and Anna. Thank you very much.
Thank you, Jeff, for the kind words, so much more benign than I expected. So thank you for that. So Scott and I have split up our topics today. I'm going to be dealing with the topic of interim distributions of property. But when I say split up the topics, that's not quite accurate because all of the work involved in writing the paper was done by Scott and his associate Kimberly Santerre, and I am very grateful to them for taking on that work. So I'm talking about interim distributions, and those of you who remember practicing under the FRA, and I'm being reminded yesterday and today that that is a shrinking pool of us when I look at some of the people here today. Under the FRA, Section 66, we could make applications for interim distributions, but it was fairly limited power. You could get an interim distribution to fund disbursements related to experts and in very limited cases to fund legal fees. That's changed under Section 89 of the FLA because the FLA now provides that the court can order an interim distribution of family property at issue if it would not be harmful to the interests of a spouse and if it's necessary for one of the following things: funding a family dispute resolution, funding all or part of a proceeding under the FLA, or obtaining information or evidence in support of family dispute resolution or an application to court. And just a reminder, family dispute resolution includes assistance from a family justice counselor, services of a parenting coordinator, mediation, arbitration, collaborative family law, and prescribed processes. Now, none of the cases that you will see in the paper involve an application to fund family dispute resolution. And you know, I have to say, if you've lost an interim distribution application to pay for family dispute resolution, you're probably not going to go into the ADR in the best frame of mind. But, you know, that ability is there, and, you know, I encourage you to take that up. In the McKenney decision, Mr. Justice Fitch ordered that an exception to the restraining order that the husband was subject to was that he could use $77,000 to pay for various experts and for a family mediator. But this wasn't an interim distribution. It's not clear from the reasons that the wife had asked for that. and the source of funds was a tax refund that the husband had received many years post-separation. So I don't think you could characterize it as family property at issue in the proceeding. So what is the purpose of Section 89? Madam Justice Balance described it essentially as a way to help economically disadvantaged spouses access justice in matrimonial disputes. And it's meant to help level the litigation playing field, and that's a term, leveling the playing field, that has been taken up in subsequent decisions. And, I won't read all of the quote here because you're all capable of reading, but I think what this represents is a very elegant expression of the motivation behind a lot of family law decisions in BC, what is fair. And so if you've got the economically disadvantaged spouse who doesn't have access to property and income, this is a way of doing something fair for that spouse. So what is the test to obtain an interim distribution of family property? Articulated by Mr. Justice Fitch in the McKenney case, the applicant must show that the advance is required to adequately mount a challenge to the other spouse's position at trial or pre-trial, and the applicant must show that the advance or payment will not jeopardize the other spouse's position at trial. Mr. Justice Fitch made a point of emphasizing that an order for interim distribution is an extraordinary remedy. And again, that is something that has been taken up in subsequent decisions, although generally by those judges who are denying the application for an interim distribution. Now, while this is the test, in the Barch versus Barch decision, Mr. Justice G.P. Wetherill made a note that you have to look at this test in the context of the purpose articulated by Madam Justice Balance, that is leveling the playing field between the spouses. So Section 89 says the court has to be satisfied that an interim distribution wouldn't be harmful to the interests of a spouse, and that raises the question, what is harm? So in the cases, you can see some of the things that, or particularly in the IF versus RJR decision of Madam Justice Balance, what constitutes harm. That would be actual or potential economic harm, possible tax consequences or transaction costs if property has to be sold or encumbered to fund the advance distribution, an adverse impact on the respondent's lifestyle. And, I guess that can be a bit loose, adverse impact, so I'm not going to be able to fly on my overseas vacation first class as opposed to business class. Is that an adverse impact? I don't know. If an advance distribution would prejudice the respondent's arguments for reapportionment, that might also constitute harm, and funding an unmeritorious claim might constitute harm, although this last point doesn't seem to be that stringently enforced by the courts. Madam Justice Balance did summarize that the determination of the presence of harm requires the court to anticipate and then assess the consequences that might flow from the order that's being sought. Harm does not include the fact that it might be commercially inconvenient or awkward for the other spouse to generate funds. And I'm not giving complete cites for all of the cases in the PowerPoint because those cites are in the paper, except one case that isn't referred to in the paper. I've given the complete cite for that. More interestingly, from the point of view of all of us who might be acting for an applicant for an interim distribution, harm does not mean that it might take a reasonable period of time to repay an interim distribution if the applicant is ultimately unsuccessful at trial. So, you lose at trial, and the next day you're not in a position to repay the distribution the next day. That's not harm. Because according to Madam Justice Balance, if you could only order interim distributions where you knew that the applicant's spouse had the funds to repay, either because the entitlement to family property was at least equivalent to the amount of the interim distribution, or the applicant had access to borrowing in order to fund that was equivalent in value to the distribution, that would put the relief in Section 89 beyond the reach of the most economically disadvantaged spouses. And so her ladyship said a reasonable amount of time, repayment in that reasonable amount of time, should be allowed. And just for context, what she had in mind was that it might take several years to repay. So again, if you're acting for an applicant, yay. So.
Like this?
Yay, yes. So Section 89. So what can we see from the cases? Well, what we can see from the cases is that if it's necessary to encumber some real property in order to fund the interim distribution, that's perfectly acceptable. That's been done in a number of cases. Again, more interesting if you're the applicant, the existence of a separation agreement that precludes the applicant's entitlement to division of property won't necessarily bar an interim distribution, so long as the applicant can demonstrate a reasonable prospect of success of impeaching the agreement, or a meritorious claim that is not bound to fail. Those are a couple of expressions of reasons that have been given in two of the decisions. And I will say this about the Section 89 cases. Success depends on showing that A, there's a lot of money available, and B, as it always does in family law, that the other side is a jerk. Even where there isn't a lot of money, you may still succeed if you can show that the other side is a jerk. In the TLL versus Triple JL decision, there was a $20,000 interim distribution. And the wife who was making the application, she had RSPs of $100,000 that she said, I don't want to cash those out. There'll be tax consequences. And she got her interim distribution and didn't have to cash out the RSP. But, that was because, I think, her husband was one of those guys, the self-represented litigant, who was, in the words of Master Boak, if this wasn't a scorched earth case, it was soon about to be. And, he was that guy who says, yeah, I'll represent myself because I can do it better than any lawyer. You get that sense from the reasons. So, jerk, interim distribution. Now, in terms of, and that works the other way. I mean, in the Longo decision, the wife was looking for an order that the husband's CPL on the family home be lifted so she could access $100,000 through a line of credit against the house. But her financial situation was arguably better than the husband's, and she and her mother, who co-owned the house, wouldn't agree that he should get a similar distribution. So, she was being a jerk, and she didn't get her interim distribution. Now, As with all things in family law, there's no consistency in what happens. So the fact that you get spousal support, and in some cases really generous spousal support, might be a factor that's relevant to granting the interim distribution. So in the Sigurdsson decision, Master McNaughton, as she then was, denied the interim distribution request of $160,000, and in doing so took into account the fact that the wife had been able to save $9,000 out of her spousal support that she could use towards her legal fees. $160,000, $9,000. So, I don't know that you could say that Master McNaughton was being particularly generous that day. Now, you can contrast that with the Barch decision, in which the husband had been paid $261,000 in spousal support and a lump sum payment, but spent it all on living expenses, and said, I need an interim distribution. And the judge said, well, rightly or wrongly, he doesn't have the sufficient financial wherewithal to fund the litigation. And so not only did the judge order the interim distribution, but, the husband had been looking for $60,000. He got $150,000. And, that, coupled with the rightly or wrongly, he doesn't have any money left, should leave you with no doubt that in this case, it was the wife who was the jerk. And that's, the court described the litigation as scorched earth on her part. Now, the applicant may or may not be required to liquidate other investments before an interim distribution is granted. So I've already spoken about the TLL case where the wife didn't have to collapse her RSPs. But then Karamanglu, the wife said, no, I don't want to liquidate my RSPs in order to pay for my legal fees. But she did want to liquidate her RSPs to buy a new car. So, exactly, priorities. You can just imagine the judge sitting there going, car, legal fees, come on. And so the judge noted that she did have $225,000 in investments and said, you need $30,000 for legal fees? Look there to your investments. Now, the other interesting thing about the Section 89 cases is that you might return to the well more than once in a number of different ways. So in the Negus case, there were two distributions. There was an initial distribution for $100,000, and then the wife came back to court and said, I need another $200,000. And the judge said, yeah, okay. Now, there was a lot of money at stake in that case, but, clearly you can go more than once. In the Sigurdsson case, the application was denied, but the applicant was granted leave to renew the application after valuation of certain family property was complete. And the issue there was that the husband had brought in a lot of excluded property into the relationship, and it wasn't clear whether the increase in value in that excluded property was sufficient such that the wife's 1/2 interest would cover the amount of the distribution she was seeking. And so once they had the valuation of the family property, then they'd know whether her half of the increase in value covered the distribution. Now, that seems to me to be inconsistent with Madam Justice Balance's caution that you shouldn't require the applicant to have a minimum entitlement to property to cover the amount of the distribution before granting one. And it's not clear to me why a lower amount couldn't have been awarded to the wife. She was asking for $160,000. Surely less could have been awarded to her. And then in TLL, that case where, the wife got $20,000 even though she had her $100,000 in RSPs kicking around, she was granted liberty to apply for a further advance if she exhausted the interim distribution prior to trial. So, I've just summarized here on this slide. These are the cases in the paper plus one other. And you'll see that, more often than not, interim distributions are granted. So that's good. Again, if you're acting for the applicant, not so great if you are acting for the respondent. So, what kind of evidence should you think about leading when you are acting for the applicant? Looking at the cases, there have been successful applications made when it's clear that the action is quite complex. You obviously should see some economic disparity between the spouses. And if the respondent spouse has significantly greater income or assets than the applicant spouse, it is more likely than not that your application will succeed. If the other spouse has been difficult or applied scorched earth tactics, has been the jerk, then you stand a greater chance of succeeding. If obtaining financial disclosure has been an issue, good for your application. When you're bringing an application, you will want to lead some evidence about legal fees that have been incurred or are anticipated to be incurred. Madam Justice Balance talked about how it was preferable to provide a budget, a litigation budget, although she noted that failure to provide a budget is not necessarily fatal. But I will say in those cases where the application has been denied, one of the complaints you do tend to get from the judiciary is, well, there's no budget, there's just a bare assertion that this is what the fees will be. But this raises for me some interesting issues, like how do you provide that information? Is it an affidavit from a lawyer? In the Sigurdsson case, there was an affidavit from a partner of counsel for the applicant. Is it an affidavit from the applicant on information and belief? My lawyer tells me that it'll cost this much. I'm a bit concerned about solicitor-client privilege issues in that regard. Can the lawyer be cross-examined on the affidavit if he or she provides that estimate? Can the client be cross-examined about the estimate? And, how much does the budget matter if in the Barch case you ask for 60 and the judge gives you 150? So, those are some questions that I'm sure that we'll have to grapple with in the future. You will also want to have some evidence of the amount owing to experts or anticipated to be charged by the experts. You will want to show that you're unable to cover the legal fees from your earnings or other sources of funds. You'll want to show what your other financial commitments might be. Now, again, there's an interesting comment in Wren versus Emerson, a case in which the application was denied, and both parties agreed that at the end of the day, the wife's entitlement to family property was going to be a minimum of $350,000. And so in dismissing the application, Mr. Justice Schultes said, she's going to get at least $350,000, and she has not explained how that seemingly reliable outcome cannot be leveraged into an arrangement for legal fees. Now, I don't know about you, but I read that as a query by the judge as to why the lawyer couldn't carry the legal expenses, knowing that he'd be paid at the end. And while many of us may do that, I don't think it's appropriate for the court to be suggesting that we do that in preference to the respondent spouse doing it if you are able to meet the requirements of Section 89. The other thing you should show when applying is that the applicant will suffer significant tax consequences if assets available to that spouse have been liquidated. So, for example, you've got an RSP that you need to liquidate to pay your legal fees. Of course, you're going to hand a good chunk of that over to Mr. Morneau. Another thing that is useful to show when you're applying is in a situation where the respondent controls a company, if you're able to show that the spouse is able to get the company to pay personal expenses, that the company has equity in property, that the company has a good income stream or cash reserves, or owes shareholders' loans to the spouses, you may find that the court is more inclined to order the interim distribution. When you're defending, what you might want to lead in terms of evidence are facts that suggest that the claim to family property is unmeritorious. For example, there is a marriage agreement or separation agreement that purports to limit entitlement, or that you had a short period of cohabitation, or there's post-separation contribution to assets made by the respondent. Now, the thing about the separation agreement, you've got both Barch and the IF case that say, look, just because the separation seems at first glance to bar your entitlement, that's not necessarily going to be fatal to your interim distribution application. So relying on the separation agreement or the marriage agreement isn't going to be a slam dunk, but you'll want to trot it out anyway and make that argument. Now, the flip side to the applicant saying, oh, I can't liquidate, the property I do have because there will be adverse tax consequences or transaction costs, well, that argument applies equally for the respondent. So you'll want to lead that evidence as well. You will want to tell the court that you've got a claim to unequal division of family property, and so you want to avoid the interim distribution because that might upset your argument for unequal division. You might want to point to the fact that the applicant doesn't have as much need for an interim distribution because things such as payment of expert fees are already being taken care of. So that was the case in Stober versus Stober, where the husband had already agreed that $75,000 would be put aside to fund the business valuators and the real estate appraisals and all of those things that needed to be done. And again, in that case, Ms. Stober was getting some fairly handsome spousal support, and so the amount of the interim distribution that she got was half of what she was asking for. If there are impediments to accessing family property, such as RSPs that are locked in, you'll want to advise the court of that. You'll want to give evidence about the harm to lifestyle, that inability to fly first class on your overseas vacation. And you'll want, of course, summing it all up, to say to the court, the litigation playing field is already level. And that is what strikes a chord with the bench. In a couple of decisions that are referred to in the paper, that's what the court has talked about. The field is already level. So, there's a lot of scope for use of Section 89. As I say, it doesn't seem to have been used to fund alternative dispute resolution. So, take that up, because, we all know ADR is a good thing. But there has been a lot of use so far of Section 89 to fund legal fees, and I'm sure that will continue. So that's me.
Thank you, Anna. That was excellent. Thank you very much. Mr. Booth?
Jeff once asked me a question in front of a group similar to the size of this group, which had the whole room laughing and had me read for about 30 seconds and speechless. And I'll never forget it. It was pretty funny. But I'm always nervous when Jeff gets up.
And I never let you live it down.
Yeah, and then Anna reminds me of it all the time.
Repeat it?
When I'm done. Thanks everybody for this opportunity. I'm gonna speak to you this morning about excluded property. It's a subject that I've spoken on before, but what I'm going to focus on today is where we are at post-VJF with the loss of excluded property claims, and specifically. The issue is what happens when excluded property is transferred from one spouse to the other. Do you lose all of the exclusion? Do you lose none of it? Do you lose part of it? And I should say before I go on further that for those of you who are not following along on laptops or tablets with the material, I know that they've placed some of the PowerPoints in note form on the desk or on your table. And the other thing I should say is this, that everybody who knows me knows I'm a bit of a numbers geek, and I often come to these things with spreadsheets. There's no real numbers in this presentation. This is about legal principle, but I still couldn't resist, and I used a spreadsheet. CLE has kindly attached Schedule A to my paper, which is a spreadsheet summary of all of the cases, highlighting things like whether presumptions were used, whether the case followed VGF. But in reproducing it in the materials, it's a big spreadsheet. It's a bit illegible. So what I've asked them to do, and what I understand they're able to do, is to post the Excel spreadsheet to the website where the materials are located. So you'll be able to download the original spreadsheet, make any changes and annotations you want to it. And as new cases come out post-VJF, if you choose to use it, you can add to that. So I hope that creates some utility in the spreadsheet, but concede that what you've got attached to your paper is a little hard to read. All right. So what happens when excluded property is transferred from one spouse to the other? We know the issue. A spouse has excluded property. They transfer it into joint names or solely into the name of the other spouse, as in the VJF case. Do they keep it? If it's transferred into joint names, do they give away half of it because they're still retaining half of it? Or do they do what happens in some other provinces, most notably Alberta, where the logic is that you only gave away half, so you've got that 50% as your excluded property, the other 50% is family property, so we'll split that in half, so in effect you've got 75% of your exclusion. I'm going to, for most of the room will be familiar with VJF, but I'm going to spend a couple of minutes just doing a brief recap on that.
Please don't.
Oh, sorry. Argued by preeminent counsel on both sides, Jeff Rose and Paul Dakin on one side, and Lisa Hamilton and Julie Brown on the other. Important case, and so I got to recap it. Sorry, Jeff. I am then going to recap what I think is a bit of a confusing area both in terms of for the courts and counsel dealing with it, and also in terms of the history of these presumptions and how sort of important they are. I'm then going to go through the post-VJF cases, and specifically I'm focused on cases that have cited VJF and deal with transfers between spouses. I'm also going to deal with a few cases that don't cite VJF, but deal with transfers between spouses. And then I'm going to make some observations. And when I started this project with Kimberly, I had the ambition and probably arrogance, really, that I would get to the end of this and be able to, reconcile the cases and tell you the answer about what happens in these situations. And I'm left unable to do that.
We're still in business.
Yeah, we're still in business. But my hope is that, in briefing the cases and in providing some of these observations, that it sparks an idea in some bright person's mind in this room that then gets leveraged into a great submission, and we start, getting a little more clarity and consistency in this area. Now, there are at least 14 post-VJF decisions citing that case. The at least is me covering my butt. That's Canley tells me there's 14. There are 3 Court of Appeal decisions, but one is an FRA case, and the other 2 cite VJF for other issues. They don't deal with the transfer issue, so no further help from the Court of Appeal, with no disrespect intended. There are 11 Supreme Court decisions, but 3 are not on point. They involve a failed summary trial and transfers from parent to child spouse, as opposed to transfers between spouse, so I'm not dealing with those. And then there are at least 3 other Supreme Court decisions not citing VJF, but dealing with transfers of excluded property between spouses. And what I can tell you right now is that Alberta solution of 75-25, where you transfer to joint names, you keep half and you've given away half, but then you get half of the half you gave away as family property. That is not something which has been recognized in the cases in BC so far, so you won't hear me talking about that further. Obviously, if you have questions about that at the end, I'm certainly happy to discuss them. All right, so quick recap of VJF. This involved a $2 million gift to the husband. It clearly would have been excluded property had he retained it in that form. However, he contributed it to the purchase and improvement of some real estate, and he placed the real estate in the sole name of his spouse, and indicated that one of the purposes of that was to provide him with some creditor protection. The real estate later sold, and the proceeds of sale were in contest. And up until this case, there had been, what happened here? Yeah, I'm on the right spot. There had been 2 competing lines of authority, one starting with Remham and ending in Madam Justice Fenlon's decision in PG, which said effectively, once an exclusion, always an exclusion. It's more complex than that, but that's my simplified version. And then there was another line of cases which said, no. In people's lives, they make decisions about what they do with their property, and they rely on those decisions, and somebody can effect an intention to give away their excluded property by saying, look, this is beneficially yours, spouse. You don't need to have, in other words, a Section 93 enforceable agreement to give away your exclusion, and it's not the case that once an exclusion, always an exclusion. So the key findings in VJF, with respect, I say, are that Part 5 is not a complete code. In other words, the common law and the equitable concepts of ownership, resulting trust, those sorts of things still exist and coexist alongside the statute, and unless they're expressly overridden by the statute, and in this case, the court found that they weren't. In order to trace or follow excluded property to subsequently acquired property, a spouse seeking the exclusion must derive an interest in the property to fit within Section 85(1)(g). So court makes it clear that just like we had under the FRA, you have a triggering event, that's when you characterize property. Triggering event now, although I don't know if we should call it that, is separation. And that's the appropriate date to characterize both family and excluded property. If you're going to assert an exclusion, you better be able to trace or follow it through to the property that exists at the date of separation. And not only that, this was an important finding from VJF, you actually had better retain an interest in that property. So if, as in VJF, you have been found to have intended to give away the entire thing beneficially, you've not retained any interest in it. There's no derived property. And that term is the term that, of course, is used in Section 85.1G. 85.1G is the so-called tracing provision. Property derived from excluded property is also excluded property. So obviously, excluded property can change form from when it's originally received through a relationship. But on the day of characterization, the date of separation, you'd better be able to say that the spouse asserting the exclusion still has some beneficial interest in the property into which the exclusion is being traced. And again, this is the big one where a spouse intends to give the beneficial interest to their spouse, as Mr. F was found to have done. The exclusion is lost. That was a big loss. No, I didn't say lost, Jeff. More key findings. Where evidence of intention is not conclusive, the presumption of advancement continues to apply from married husband to wife, and the husband bears the onus of proving that a gift was not intended. Now, arguably, this particular finding is obiter, and I say that because, and we'll get into some of the discussion about presumptions in a minute, really the presumptions are only supposed to operate where you don't have adequate evidence of intent, and the court, the Supreme Court and Court of Appeal both clearly found that when Mr. F decided to put the property into his wife's name for creditor protection, he intended to give her the full beneficial interest. And with that finding, the presumption really shouldn't operate or really be an issue. But nevertheless, the court discussed it and said that, look, these things, if the legislature had wanted to do away with these presumptions, they could have done so, and they didn't. So they still exist. While a transfer for creditor protection is not generally objectionable, a party should not be able to rebut the presumption of advancement on the basis that the transfer was a sham. The court called this a prevarication, which should not receive a court's blessing. So the idea here is that the court did not want to appear to countenance a situation where Mr. F is saying to creditors, hey, I got no beneficial interest in this property, you can't get it. And at the same time, as between himself and his spouse, say, actually, really, this is still mine. Not half mine, all mine, because it's my exclusion. And they called that the prevarication, which I looked up. It means a sham or a lie. Now, so that's my quick recap on key findings from VJF. What I want to do now is spend a little bit of time on burden of proof, and also the presumptions that I talked about earlier, because this is a confusing area where certainly when I was reading the cases, I ended up confusing myself several times, and I think by the time I got everything down in the paper, I think it's right. The burden of proof to prove an exclusion is set out in Section 85.2. It's on the spouse alleging the exclusion. In the early case of Asselin and Roy, Mr. Justice Harvey set out that the evidence must be led to both establish the value of the excluded property at the time a spouse received it or at the time the relationship was commenced. That's the trigger point for beginning to calculate growth. And that they also have to be able to show that it can be followed or traced into property that exists at the date of separation, which is fairly obvious, I think, for the purposes of Section 85.1G. The question early on in practitioners' minds was, well, what level of evidence do I have to get? Because, for example, in a long relationship where you have an investment account with money moving in and out all the time, how do I show that what was originally in there is still intact in there today? That's a pretty complicated exercise. Do I have to be able to trace every single dollar? And the answer, thankfully and practically, is no. More recently, the Court of Appeal in She versus She clarified that the standard of proof is proof on a balance of probabilities. that you should lead clear and cogent evidence with respect to, again, value and the traceability of the exclusion, but that inferences can be drawn and mathematical precision is not required. So, for example, if a significant item of property is excluded or I beg your pardon, is obtained, and the allegation is that somebody's inheritance was used, and you're able to produce a contemporaneous document, the will, for example, or the letters probate, that one of the spouses received a significant inheritance, and there's no possible other explanation for them acquiring that valuable asset. Even if you don't have the banking documents, you're likely producing sufficient evidence to permit a court to draw an inference that the exclusion is traceable. The court held that documents should be provided wherever possible, but if conclusive documents are not available, testimony, subject, of course, to testing through cross-examination and in court's discretionary conclusions about credibility, may be sufficient to establish the exclusion. Now, presumptions of resulting trust and advancement, and I apologize if some of this is overly simplified, but I sort of started with basics. A presumption, it's a legal assumption the court will make absent satisfactory evidence that the assumption is correct, and that's key. If there is evidence of intention in these cases of transfers between spouses, the presumption is not what governs. The finding of intention is what the court must reach. The party opposing a presumption bears the burden of adducing sufficient evidence to rebut it. So there's an onus issue within the analysis dealing with these presumptions. For gratuitous transfers, the usual rule is that a presumption of resulting trust is the norm, meaning a gratuitous transfer from A to B, no consideration. It's presumed that A still retains beneficial interest. Equity presumes bargains. And that means that quite often if we're now translating it into the family law context, if the presumption of resulting trust was always the default and we didn't have to worry about this pesky presumption of advancement, you would always, within the analysis, as long as the transfer is gratuitous, that's key, because you can imagine there'd be arguments that, well, he transferred the excluded property to me because I said I'd work in the business for free. So that might not be a gratuitous transfer. But if it's clearly gratuitous, then the effect of a presumption of resulting trust means that the party who is opposing the exclusion bears the onus of adducing some evidence to show that the presumption of resulting trust is rebutted. And when I was writing the paper, I thought, this is a little counterintuitive because, it's the party who's seeking to establish the exclusion that has the onus of proving the exclusion. So you're telling me that within the context of that exercise, if there is a presumption of resulting trust, it's actually the party opposing the exclusion that then has the onus to lead some evidence to rebut the presumption. Can you
imagine being hungover and trying to figure this out? I'm sorry.
No. It's yeah. Are you, Jeff? Am I keeping you awake?
No.
So yeah, that bothered me, and in fact, there's a line that CLE will correct it. There's a line in the paper where I say this bothered me, and I'm going to take it out because it doesn't bother me anymore. Because I then found some other cases that really provide the answer here, I think. And that's cited at the bottom of this slide, Hilborn and Wright and Dhaliwal and Olek. And those were cases where the court had to consider the effect of Section 23 of the Land Title Act. So we're getting afield a bit of our typical family law fare, but Section 23 basically says that the Land Title Register provides conclusive proof that the person who is on title owns the title, right? So you read that statute and you say, well, that's pretty clear. But historically, the courts have held that, no, that's subject to a presumption of resulting trust. And if someone can show that title was put into somebody's name, it's not conclusive. And so, again, unless the statute expressly does away with these equitable and common law principles, courts are going to apply them. Even though in our statute in Section 85.2 we have an onus That's not inconsistent with these equitable and common law principles being brought in to create a little kind of onus flip, if you will, in the middle of the exercise. The leading case on these presumptions is Pecor and Pecor, Supreme Court of Canada, 2007. And that case held that the presumptions provide a guide for courts where evidence as to the transfer's intent in making the transfer is unavailable or unpersuasive, and a measure of certainty and predictability for individuals who put property in joint accounts or make other gratuitous transfers. And I mean no disrespect, but it's just there's some irony in the fact that we're all confused as heck trying to sort out this stuff, and it provides a measure of certainty and predictability. Presumption of resulting trust, general rule, I've already said that, I should say. And the presumption of advancement is the opposite rule. It's a presumption that a party transferring intends to make a gift. And it applies to transfers between parents of either gender and minor children, and transfers from husband to wife. So there you go. Before applying the presumptions, the court must weigh all the evidence in an attempt to ascertain on a balance of probabilities the transfer's actual intention. So again, let's not overstate the importance of particularly the presumption of advancement. If there's evidence with respect to intention, that rebuts it and that rules. The evidence of contrary intention is evidence at the time that the transfer was made, and circumstantial evidence may permit an inference of intent. Conversations with the spouse, course of conduct that shows that generally, for example, in the cases we're looking at, you don't like to share. And evidence of intention that arises subsequent to the transfer can and should be weighed in the analysis. So acts consistent with gifting or not gifting post-transfer can be looked at, but the court in Pecor said they should be scrutinized carefully to guard against self-serving evidence or a change of intention. All right, so let's get to the cases, and I'm going to go through them in order of time after VJF was decided. So the first one is a case called Bell and Stagg. Relatively brief 5-year relationship between unmarried spouses. The claimant was 70 and the respondent 53, so later in life. No children together, although the respondent had a child from a prior relationship, but adult at the time. The claimant husband put a $60,000 down payment into a home, and his evidence was that they put the home solely in the name of the other spouse because he did not qualify for a CMHC mortgage because he was a U.S. citizen. When he put the property into the name of the other spouse, he also authored one of these gift letters that you give to lenders. So the lender can be confident that they're not going to be faced with some equitable claim that purports to be ahead of their mortgage. So they financed, there was down payment, he gives a gift letter that says, I'm giving this money away. And that's, I've mentioned prevarication here, that's obviously inconsistent with the position that the husband took at trial and in asserting that the exclusion was preserved. The presumptions were discussed in the case, but the court found that evidence of the husband's intent overrode the gift letter, and the result in VJF was distinguished on its facts. And the interesting thing, or the most interesting thing I think about this case, is that this case involved the prevarication, if I can call it that. I don't know. Do you guys think that's a sham if you do a gift letter but you didn't really mean it? Anyways, it just seems like the court. Didn't really get bothered by that. Now, in fairness, this case also involved a concurrent agreement. Gives the gift letter to the bank, but enters into another agreement with his spouse saying, our down payments are going to be preserved. And before you get all over me and say, oh, well, no, this case is about an agreement and enforceability of an agreement then, Booth. It's not about intention. No, it's also about intention because there was a challenge to the agreement under Section 93. And the court was asked to look at the issue of significant unfairness. And in analyzing the issue of significant unfairness, one of the things that the court had to look at was, well, would this have been excluded but for the agreement? And the court found no, it wouldn't have been. The evidence of intent is clear both from the written agreement and from other conduct that the husband engaged in.
It sounds like a case where there might not have been an interim advance.
I have no idea, actually. That's my...
Well, it embodies all the factors that Anna was talking about that would be making an interim advance objectionable.
Yeah.
I'm just trying to bridge the gap between these two here. And,
yeah. Thank you.
Synergy. I want to do synergy.
So the next case I want to talk about is Kalmiakov and Shilova. This involved a 15-year relationship. Again, the parties separated later in life. Claimant husband at 59 and wife at 56. There are no children of the relationship. This was a summary trial determination, and the wife had owned a property prior to the relationship and was able to trace proceeds of that through to property owned at the end of the relationship. And in addition, her mother had advanced $65,000 to her for the purchase of a later property that the spouses resided in as the family residence. And in this case, it was the wife's mother that signed one of these gift letters saying that she intended the gift to be to both spouses. And normally the finding there is if a third party gives a gift to both spouses, it's family property. Or it's, I suppose, actually, if you look at Section 85, it would be they'd each have 50% of excluded property because it's a gift from a third party. But in any event, they'd share it equally if it was a gift to both spouses. And the issue was whether really it was a gift to both spouses, despite the gift letter saying that. And there was no discussion of the presumptions in the case. And there was also no discussion of the wife's intent at the time that the funds were placed into the property. And there was discussion of the mother's intent, but the court found that despite the gift letter, the mother actually intended that the gift was solely to her daughter. And there was no discussion again of that sort of prevarication issue. What you're coming to court and telling me is inconsistent with what you wrote in the letter to the bank. And VJF was not considered, as I've already said. So, curious. The next case is Laticorpi and Laticorpi. In this case, a long 36-year relationship. During the relationship, the wife received a $30,000 inheritance. And by the way, all these cases are fully briefed in the paper, so they're not. The facts aren't sitting here on the slides, but they're all there for you in the paper. During the trial, the husband had conceded that the $30,000 inheritance was the wife's excluded property. So he conceded that, and then they wrapped up, and the VJF decision came out. And then he went back to court and said, "Wait a minute, based on VJF, I say that the presumption of advancement applies, and when my wife put this in joint names, she loses her exclusion." And court determined that the wife transferring her excluded property into the joint property did not cause her to lose her exclusion. Presumptions of advancement or resulting trust were not considered. There was also not much discussion of the wife's intent at the time of the transfer, which, again, that's supposed to be the key issue, according to VJF. The court, and I mean, in this respect, seemed to be approaching it as though, well, there isn't really evidence of an intention to gift, which, again, the presumption of resulting trust wasn't mentioned, but in my respectful view, it's a lot like applying the presumption of resulting trust. It seems almost like the onus was on the husband to assert positive evidence and facts to show that it was in fact a gift. Otherwise, it remains the wife's property. The case distinguished VJF on its facts as the wife always retained an interest in the property. And this is a really important point about some of this decision and the subsequent decisions. They draw consistently, there's a number of them, a distinction between transfer to joint property and transfer to sole name. In VJF, if you recall, one of the reasons Mr. F lost was because the court held he derived no interest in property solely in his spouse's name. In the joint transfer scenario, courts say, no, this is totally different. You're clearly deriving an interest, and because you derive an interest, maybe you retain your whole exclusion, even though someone else might argue you've given half of it away. That given half of it away argument, as I say, that's the one that follows more the Alberta line of cases. We don't see a lot of that in BC, or we haven't seen any of that in BC. All right, the next case, KR and JD. In this case, shorter 7-year relationship. Parties were middle-aged and had a 7-year-old child. The husband argued that certain investments by him in pre-relationship property could be traced to the family home, such that he had a claim to excluded property. But ultimately, the court determined that the husband was not entitled to an exclusion because he lacked the requisite documentary evidence as established in the She decisions. There was no evidence about the sale price of his first property from which he said the excluded funds came. So he failed on the sort of traceability part of the test, but the court did also consider the issue of the presumption of advancement and whether it could be said that he'd lost the exclusion by virtue of just putting the property in joint names. And the court expressly held that there was no presumption of advancement that applied to a transfer from one spouse to the joint names of the spouses. So this is a qualification that at least I didn't previously see in the cases considering the presumption of advancement. It just doesn't apply at all if the transfer is into joint names. And this case and a couple of the others seem to suggest that is so. So that's going to be quite useful to you if you're asserting an exclusion for someone who's transferred into joint property and you're troubled that the evidence isn't the strongest. The case distinguishes VJF on the basis that it applies to a transfer to the sole name of the other spouse, and the court cites the VJF paragraphs where it observed that property gifted solely to the other spouse means that they've derived nothing. So again, that was key to the finding in KR and JD. Next is, Alekshevich. I hope I got that right. In this case, longer marriage, again, 25 years. The wife had contributed funds of approximately $22,000 from the non-pecuniary damage portion of a personal injury award, which under Section 85, that's held to be, or that is stated to be excluded property. And the court held that she had met the evidentiary burden to trace that through to the family residence, which was in joint names, and the court considered the effect of the title being transferred and found that it was, quote, more likely than not, end quote, that there was no intent to make a gift. So again, it's just a bit hard to sort out because if the onus is on the party seeking the exclusion to prove it, you would think there would be some strength of the evidence to not gift. But it's kind of like the court, again, practically applies a presumption of resulting trust and says, look, it's more likely than not, and I'm going to infer that there was no gift. And the court also expressly held, as the court in the previous case, KR and JD, that no presumption of advancement arises on a transfer to joint tenancy. There was some other, to be fair, there was some other discussion of intent. The wife had kept, up until the time she put it in the property, she kept her personal injury proceeds separate. I don't know. That seemed to be significant, although it doesn't make a ton of sense to me with respect, because of course the excluded property is always initially separate. She'd purchased other assets, namely a vehicle, an old Crown Victoria that they called the Vicky, with the proceeds, and she kept that in her separate name. So that was evidence that she didn't want to share. Anyway, at least there was some discussion of intention. And also VJF was not considered in that case. Dean, Shaw, and Gill. This is a case where the wife received a gift of $10,000 from her mother. Actually, I'll let you read the brief because it's complicated. It goes through multiple properties, but the bottom line is the wife argued that she was able to trace gifted property to her through to a residence that the parties held in joint names. And then what happened after separation is they sold that residence and unreservedly split the proceeds of that residence equally. And she still tried to argue for an exclusion because at one point they had taken the equity in that residence and bought a commercial property in Edmonton. And she said, oh, look, we pulled equity out of the home into which my exclusion is traced, so you can trace that over to the property in Edmonton. And the court said no. When you unreservedly split the proceeds of the residence into which I agree you can trace your exclusion, you gave away it all. The court did not discuss the presumptions in relation to the acquisition of the jointly titled property, but it relied on laticorpi and the evidence of the wife's intent at the time of the transfer was not discussed. So again, this is a case that kind of falls into the grouping that if you put something in joint names, no presumption of advancement is going to be held to apply, even where evidence of intent seems either absent or equivocal. The next case is Donnelly and Weekly, and this case involved two parties, later in long marriage, 27 years, late 60s and 70s, so later in life they're splitting up. And the facts relating to gifts and inheritances in this case are also complex. The primary focus of the case was whether a separation agreement might be voided at common law or set aside under Section 93 of the FLA. And in considering the issue, like the earlier case, of whether to set aside the agreement, the court reviewed the wife's claims that certain gifts and inheritance she had received during the marriage ought to have been recognized as her excluded property. And the court says that since this is a situation where we have transfer from wife to husband, presumption of advancement doesn't apply at all, right? It's just husband to wife, not wife to husband. Completely, I think, somewhat inconsistent with the other cases. The presumption of resulting trust applies. So by making the transfer, there's no automatic loss of the exclusion. But then, very helpfully, the court goes on to discuss evidence of intent, and numerous factors allowed the court to infer intent, including a fairly lengthy history of the wife receiving gifts and consistently sharing them, acquiring other joint property, spending on the party's lifestyle, and such. And the court relied on that evidence as circumstantial evidence of an intent generally to share with the husband. So I thought that case, again, with respect, was quite helpful because of that discussion of intent. VJF was cited and distinguished regarding the presumption of advancement, but again, the point is, look, it doesn't apply if it's wife to husband. KAL versus KJL. Okay, this one involved, this has a couple of interesting points. 25-year relationship. During the marriage, the claimant received an inheritance of about $140,000 from an aunt. The claimant wife placed those funds into an investment account in her sole name, and she also put some of the money into jointly titled property. And the question was whether she retained her exclusion. And how she put money into jointly titled property was really an interesting feature of this case. It wasn't that she took a big chunk of money, it was the income generated on the $140,000 investment fund that she put in. And the court actually considered that the income generated on the investment fund is perhaps derived from excluded property and then found its way into the mortgage payments, and therefore the equity in the joint property bumped up. The court held that the presumption of advancement did apply. So exactly the opposite of Donnelly and Weekly that we just looked a second ago. It's wife to husband, but presumption of advancement applies, and the court applies VJF, and there isn't really a discussion of intention at the time of the transfer. And I just comment at the bottom of the slide that the conclusion that income generated on excluded property may be derived excluded property, that's the only case I've seen that idea expressed in, and it strikes me that it seems contrary to Section 84 2G that growth and value of excluded property is shared. If one could just continuously peel income off of most types of excluded property, where's the growth if that income ends up being also excluded property? We're getting there. CLM and MJS. This case actually, and again with the greatest respect, very well written decision, very good reasons, and helpful to a significant extent. Although again, it seems like although VJF has said intent is key, discussion of intent is light. During the relationship, the parties purchased a home. This was a 7-year relationship, so not a long one. Neither party had funds for the down payment, and some funds were provided by the claimant's mother, which were an acknowledged gift to both, but a further sum was advanced by the claimant's father. There was a dispute about whether those further funds from the claimant's father was a gift to the claimant alone or to both parties. The court characterized the evidence of the parties about the characterization and tracing of the $50,000 as vague, but it was common ground between them that the funds had been used to purchase the home, so the tracing part was established because it was common ground between the parties. And then the claimant called her father, claimant wife called her father, who gave testimony to the effect that when he advanced the funds, he intended the gift to be made only to his daughter. The property was registered as to an undivided 99/100ths interest in the respondent and a 1/100th interest in the claimant, and the respondent's evidence was that was done to take advantage of a first-time home buyer's credit. The court cites Alexevich, in which it was held that presumption of advancement did not apply in transfers from wife to husband, and the evidence of intent. Of course, the court discussed fairly thoroughly the evidence of the father's intent to just gift solely to his child, but the evidence of intent when the funds are placed in joint names wasn't really thoroughly discussed in the case. The court found that it could not infer an intention to gift. So again, like I've observed with a couple of other cases, it almost feels like the presumption of resulting trust is applied, which if you're from the school of thought that that should be the default presumption, that does apply, and that of course, because this is a transfer from a wife to a husband, advancement doesn't come into it, then I suppose it works. VJF was distinguished with respect to the presumption of advancement because this is a case transfer in joint names. So again, we're seeing that as a fairly consistent theme now between several cases. Just doesn't apply to transfers to joint names. Court doesn't expressly say that in this case, but that's the effective result. All right, last one. Bamford and Muliati. This case involved, you know what? take this case with a grain of salt. I'm going to touch on it because I said I'd do every case.
I think we'll take it with another cup of coffee soon.
Yeah? I'm not keeping Jeff up.
No.
Oh, it's great.
No, I'm just thinking that, the drafters of the FLA would turn over in their graves if they were here for this part of this.
Yeah. No, it's like I said, I kind of started this and went, you know what, I'm going to get to the end of this and I'm going to be able to tell everyone how this works. Sorry. So in this case, the reason I sort of say take it with a grain of salt is because this case involved an unopposed trial. The elderly husband claimant in his 80s, his wife in her early 50s, left to Indonesia, and she didn't participate in the proceedings at all. And he had, of course, all kinds of property because they got together later in life that he claimed was excluded, and he really wanted to keep 100% of everything here in BC. And he had, at one point, unfortunately, put his property into joint names. And so this point was addressed in the decision. But again, it's addressed in a case where nobody's arguing the contrary. But the court did not consider presumptions and did say that there was sufficient evidence of intention to negate its application. Didn't discuss a bunch of, there's no express evidence in terms of agreements or contemporaneous documents, but drew a conclusion that when the claimant transferred his interest in his home, he did so on the condition that he and the respondent would be together till he died, and then she'd have a right of survivorship. So it's more like, I guess the way I'd put it is a rationale for why you did the transfer that is inconsistent with it being a gift seems to be helpful, is what I would take from this case. All right, so where the heck are we? You've just listened to me for over half an hour go through these cases, and some of them seem irreconcilable, and they might be. But where are we? A summary of them. One case, where are we after VJF and this whole issue of intention decides what happens when you transfer into the other spouse's name. One case was decided on the basis of a valid Section 93 agreement. Significant unfairness was considered, but look, an agreement, a written document, pretty good evidence of intention. One follows VJF in the result and applies presumptions of advancement where the wife placed funds in joint names. That's KAL. One does the opposite. That's Donnelly, and holds that presumption of resulting trust applies to transfers from wife to husband, but then considers an intention to gift and finds a valid gift. The remaining four distinguish VJF, and these are the VJF citing cases, on the basis that it involved a transfer in the wife's sole name. So transfers to joint names, you don't give it away, seems to be the theme from those cases. And then there are the other cases that don't cite VJF. There were three of them that I took you through that seem pretty consistent with that theme as well, that if it's into joint names, you're not going to be subject to a presumption of advancement. And the evidentiary, I'll cover this a bit more later, the evidentiary burden seems to be pretty low in terms of establishing intention that it wasn't a gift, or the presumption of resulting trust is operating, and the other party failed to adduce sufficient evidence to say that the interest or the intent was to gift. All right, there was no mention of presumptions in three cases. All involved transfers from the wife to the joint names of the husband and wife. There was little discussion of intention, and with respect, that's the presumption of resulting trust practical effect point that I've tried to make. In three cases, the court appears to rule that there is no presumption of advancement applicable to a transfer from one spouse to the joint names of the other spouses. And I covered the difference between the first point there between Donnelly and KAL. Okay, observations. This is the part that is supposed to be the most pithy. This was where I was actually supposed to have solved the problem for you guys, and I failed. The importance of presumptions. Okay, look, it's difficult to resolve the cases in terms of how they deal with the presumptions. There's some inconsistency. But before we despair and go, oh, look at our lot in lives as family lawyers, the FLA was supposed to be clear and simple, and now it's even more of a mess than things were before. I don't think that's fair, really. Evidence of intention overrides the presumptions. That's clear from PCOR and VJF. So look, you got to guard against self-serving evidence, because everyone who comes to see you, who learns about exclusions for the first time when they're sitting in their office, of course, is going to have these retroactive versions of what their intention was. But I mean, when you drill down and cross them yourself, like you usually do when you're preparing witnesses, you've got to look for the little bits and pieces that establish intention. The presumption of advancement has, according to other decisions, including PCOR and Zhu and Lee, which I note there on the slide, has, quote, lost its force. Jeff tried valiantly to argue that in VJF, and again, I'm not sure why, because it was possibly an overture. The court said, no, it's still there. But okay, it's still there, but apparently it's a pretty weak presumption. There's this commentary that's lost its force, and then you see, with some measure of consistency, the Supreme Court decisions post-VJF saying it doesn't apply to a joint transfer, or just kind of ignoring it and effectively approving a presumption of resulting trust, although they don't say that. The final note on the slide here is not really, I suppose it's slightly sarcastic, which probably isn't very becoming of me, but anyways, it is a bit annoying that we're having to do all of this mental gymnastics stuff about how this works, because really, when you think about it, should this really old presumption that has this paternalistic history about wives being able to retain property that their husbands transferred to them, does it really have any place in interpreting a modern statute in 2017, when it appears to, Part 5, of course, is supposed to apply evenly between married and unmarried. It doesn't matter what gender you are. It doesn't matter whether it's a same-sex relationship or it shouldn't. And you got this weird presumption that apparently only applies between, transfers to husband to wife, and between married husband and wife, for that matter. Now, I do note this in the paper. There's some debate in the cases about whether it also applies to unmarried spouses and whether it applies the other way. And of course, in KAL, a court applied it the other way. But there isn't a clear appellate finding anywhere that it applies that way. And in fact, in VJF, and I think it's paragraph 70 of that decision, the court sort of says, the legislature could make this apply to transfers between wife to husband. So recognition that historically it didn't, and kind of almost an invitation, legislature, fix this. And I actually hope they do, because it's annoying. With respect to evidence of intention, keeping funds, what's going to be helpful? What can you draw from these cases? Well, unfortunately, there is a grouping of them that don't seem to talk about intention a lot, but there's a few points I drew from them. Keeping your other funds derived from the excluded property in a separate account and otherwise dealing with them separately suggests an intention not to gift. Obviously, we all tell our clients, if you've got excluded property in this age of uncertainty, keep it in a separate account. But apparently it's also helpful if even if you share some of it, if you keep the rest of it in separate, circumstantial evidence of intent. Conversely, a pattern of using funds derived from the excluded property for family purchases. Again, sarcasm, sorry. Dare we say for a family purpose, suggests an intention to gift. Rescinding a prior prenuptial or marriage agreement, which would have had the effect of maintaining exclusions, signals an intent to gift. Yeah, I forgot to mention that when I was going through Donnelly. In that case, there was an earlier marriage agreement which said everybody keeps their own gifts and inheritances, and the wife had actually agreed with the husband to rescind that. So that was circumstantial evidence that generally she wanted to share with him. Also, and I mentioned this point, a rationale for transferring excluded property to joint property other than for the purpose of a gift appears to be helpful. For example, registration of title to home in joint names for financing purposes and to reflect joint use, that was Alexovich. Registration of title to home in joint names to convey a right of survivorship should the parties' relationship continue until death of the transferring spouse, that was Bamford. and registration of title to the home in the name of the recipient spouse in order to qualify for a CMHC mortgage. So, a rationale other than gift, here's the reason I did it. It wasn't necessarily to give it away. Seems helpful. A document representing that property has been gifted may not be conclusive of intention if there is evidence confirming the contrary. So this is the gift letters cases. If you have something else that says, no, I didn't really mean that when I said that in the gift letter, you're not dead in the water. And then, I'll skip that point on Dean Shaw. Pre-verifications, inconsistent statements, just following up on the last point. In my respectful view, it would be an oversimplification of what was said in VJF to look at this body of cases and conclude, look, you can't have it both ways. And whenever you've made an inconsistent statement about your intention, you're just done. If you've done one of these gift letters, if you enter into a scheme to keep a principal residence exemption when you shouldn't have been doing that. You might be putting one over on CRA, but it's not necessarily a death knell to the maintenance of a claim for keeping the exclusion. What the spouse intended at the time of the transfer is what's key, and whether they continue to maintain a beneficial interest in the excluded property is also key. That is the derived question. Do they still have an interest in it? Hu and Lee considers VJF. It's an FRA case, so it's not really what we're talking about today squarely in terms of the transfer between spouse issue. But it is, and it deals with the transfer between husband's parents to husband. Property that was solely in the husband's name was alleged by his parents to have been put in his name on a resulting trust. Wife argued that that should be family property, relied on VJF, and says, they put it in his name to scam CRA. And the court shouldn't countenance that, shouldn't approve of that. This should be held to be family property. And the court said, no, there's no strict bar preventing a party from taking one position when dealing with the CRA and another when confronted with claims against their property. And a representation is just one fact to consider when determining intention. So you have these inconsistent statements, you're not necessarily dead in the water. Now, finally, and I think I have about 2 minutes, I said I would do this when I agreed to write this paper, but I'm shifting gears now, different topic, and a very, very brief point. One of the issues that is out there that needs maybe even more work than this issue of excluded property, although it's not going to come up as much, is the issue of when an interest in a trust crystallizes for the purposes of it being characterized as excluded property. And why that's important is for the calculation of growth. And what I mean by this is, let's say it's a testamentary trust, and a spouse is taking under their parents' will. Do they take their interest in the inheritance at the date of death of their parent, or do they take it on the date that the estate actually distributes property to them? And correspondingly with discretionary inter vivos trust, for example, does a spouse take their interest in that trust or the valuable property, which is the subject of calculating growth, on the date that the trust instrument is created, or do you start counting growth when the discretionary trust actually distributes property to them? The latter one is, in particular, a horribly complex question. I don't have the answer to it. By the way, I did try and argue about it in a case last fall. The facts were so bad for me, I had no business arguing it in that case. And thankfully, the court decided the case on entirely other grounds. So there was no resolution of the issue. But I'm just going to briefly mention this decision, Parton and Parton. In this case, Mr. Justice Butler held that with respect to a testamentary trust, the date of receipt is the date that a spouse actually gets the property distributed to them, not the date of death. And there's all kinds of good practical reasons for that. If you have an optimistic view of life, that people generally tend to act altruistically, and that is, you've got a complex estate, it's got expenses, it's got stuff to do. If you start saying that the party takes their interest on the date of death, then it's going to be hard to figure out what value is before the estate's properly administered and all that. So it's just a mess if you create that as the default rule. On the other hand, one can also imagine, if one thinks less altruistically, situations where a spouse is actually in control of the distribution of the estate and says, hey, my marriage is on the rocks, and this estate holds a bunch of valuable real estate, which, because it's Vancouver, is going to steadily increase in value. I'm just not going to distribute it for a couple of years and see what happens here. And then, they separate and they say, look, I didn't distribute it to myself, so I haven't got it yet, so there's no growth in value to calculate. Now, I would be, I'm just telling you what the rule is in Parton and Parton. I would not be that comfortable arguing that point. That kind of technical argument, I think, would probably face a fair bit of scrutiny. But nevertheless, that's what Parton and Parton suggests. So those are my remarks. And as I said earlier, I don't have all the answers, and I'm sorry about that. I hope that the briefs in the paper are helpful to you, that maybe some of the ideas that I've thrown out spark one of the brilliant people in this room to get one of these cases up before the Court of Appeal so that we can all have some more clarity. Thank you.
We have one very helpful comment from online, and that is that the citation for CLM versus MJS on page 9 of the slides is incorrect. I'm so sorry, Scott. It should actually read 2017 BCSC 799.
Thank you very much, Anna and Scott. That was wonderful. And thank you, Kimberly Santerre, for doing an excellent paper. If I were applying for an interim advance, I would hand up Scott's paper to the judge, sit down, and say thank you. That's why we need money.